Okay, I am going to talk about the Oregon legislation and what bills have been presented before it, what we've seen coming out of there. As most of you know, this year was a year in which the Oregon legislature met. And as is usual, we saw just a host of bills which were introduced that impact the employment arena. And these bills ranged from ones that made you shake your head and you wonder what people are thinking, to ones that were very predictable, particularly with COVID. A number of bills that were clearly a direct response to COVID and trying to make changes related to COVID in the workplace. We're going to talk about bills that have actually become law. There have been a couple of employment-related bills that have become law. Bills that look like they have a chance to become law, and then some long shots that I find fairly interesting. I want to mention first, Erin, when she was talked about the bill that had been introduced that related to vaccination history. In doing my preparation for this, I, of course, looked at all of the employment-related bills, and the vaccination history bill is basically a non-starter. It was entered, and there has actually been no work done on it. It has not been referred to committee, so we can definitely count on that not being law at this time. Maybe in the future, but with this legislative session, it does not appear that has any traction whatsoever. Okay, so let's look at some bills that have become law. We have seen over the past couple of decades an assault on non-competition agreements. Depending on which side of the fence you fall on, you may be in favor of non-competition agreements or you may be against non-competition agreements. The justification for an employer to have a non-competition agreement with an employee is the employer's desire to protect its investment in the work, in the employee, and also to protect its goodwill with customers, and not allow an employee who finds out all about the employer to then go and work for a competitor and use that knowledge to compete with the original employer. The most recent changes that were made have added procedural requirements. The most recent one made a requirement that an employer provide a departing employee who had a non-competition agreement with a copy of that non-competition agreement within 30 days of departing, or the non-competition agreement was voidable. Senate Bill 169 actually made some pretty significant changes to the non-competition agreement statute, which have made such agreements even more difficult to engage in and to enforce. Prior, non-compliant agreements were voidable, but not void. And under the cases, prior to for the agreement to actually be voided, prior to the employer seeking to enforce it, the employee had to in some way indicate that it did not think, that the employee did not think that the non-competition agreement was enforceable. So how many employees are going to do that? Not many. So although it was voidable, not many non-competition agreements got voided. Now, the statute makes non-compliant agreements void. So the employee doesn't need to do anything. The agreement simply is unenforceable. As you were aware, I think it was a couple of legislative sessions ago, the Oregon legislature put in an income requirement, which was the equivalent to the median income for a family of 4. Well, the legislature has done away with that. They've stuck in a specific dollar figure. That income requirement is now $97,311. If an employee does not make at least that much, that employee cannot be bound by a non-competition agreement. That amount will be adjusted annually for inflation. As you're aware, several legislative sessions ago, non-competition agreements were held to be unenforceable to the extent they were longer than 18 months. Senate Bill 169 reduces that period to a term of 12 months. So now the longest a non-competition agreement with an employee can be in effect is 12 months. Now, all of the other requirements regarding having an enforceable non-competition agreement are still in place. You still have to advise the applicant in writing at least 14 days prior to becoming an employee that you will be requiring a non-competition agreement, and all of the other hoops that have to be jumped through. In light of this, I think it becomes even more important for you to consider other types of restrictive covenants to protect your businesses. These can include non-disclosure agreements, not ones that relate to prohibited conduct such as harassment and discrimination, but ones that relate to the proprietary and trade secret information that the company has. You should also look at, perhaps depending on the nature of what the employee is going to be doing, an inventions agreement, which would make any invention, anything developed by the employee while employed, the property of the employer. And of course, the most important is the non-solicitation agreement. Nothing in the statute affects the length which a non-solicitation agreement can be. And we typically see non-solicitation agreements of 18 months to 2 years upheld by the courts. The statute is actually pretty, it gives with one hand, takes away with the other, but it's not just a prohibition on soliciting customers of the employer, but also you can prohibit an employee from transacting business with that customer, which is fairly effective. It's not as broad as a non-competition agreement, but it does provide the employer with a significant amount of protection. So this is our first bill that has actually become law, and this amends non-competition agreements. So, the practice tip here is it doesn't affect any non-competition agreements which are already in place, only those that are going to be occurring in the future. But you will want to look at your templates for those agreements to make sure that they are in compliance, and you want to review the requirements to make sure that you're binding only those employees who can be bound by a non-competition agreement. The second bill, which actually became law, is Senate Bill 716, which was dubbed Reasonable Accommodation for Childcare. What this does is, as you know, there is a statute in Oregon which permits employees to have input into what their work schedule would be, and to request that they only be scheduled for certain days or certain hours because of other things in their lives. What this bill does is it amends this statute to specifically include the employee's right to input as to the work schedule to include childcare needs in the limitation or changes the employee can bring to the employer's attention for setting that schedule. Any issues that the employee has with childcare can now form the basis for requesting a specific schedule from the employer. I believe this is a response to the pandemic and the issues that so many families faced with schools and childcare settings being closed. As you know, the right to put input into the schedule isn't just at the time of hire, but it's of course at any time while the employee is working. Just as a reminder, the statute does say that while an employee has the right to give this input, an employer is not bound to take it into account in making decisions when scheduling the employee. So those are the two bills that have actually been signed into law. In fact, this reasonable accommodation for childcare was signed into law less than a week ago by Governor Brown. Now let's look at some bills that do look like they are likely to become law. And these may definitely have an impact on you and what you're doing, particularly if you are in human resources or are administering leave under the Oregon Family Leave Act. So House Bill 2474 was a direct response to COVID. It includes now as you know, we have OFLA, and OFLA leave is provided for certain enumerated reasons, all of which historically have been specifically related to, in some way, health. It was expanded to include military leave, et cetera, and for spouses to be with their spouse who was home from military leave or who was going to be deployed. But this now expands, or would expand, I can say expand because I'm very confident this is going to become law, expands the reasons to include leave for the closure of school or child care provider due to a public health emergency. So you can see that's clearly related directly to COVID. But the law goes so much farther than just including that as a reason now for protected leave. Number one, it expands OFLA to all employers. As you are aware, previously OFLA applied only to employers with 15 or more employees. This bill would expand OFLA to all employers. As you're aware, there were requirements as to how long an employee had to be employed and how many hours they had worked, depending on if it was related to pregnancy or childbirth. And that was, those were quite long. This would reduce the required length of employment to be eligible for OFLA to 30 days. After an employee had been employed for 30 days, they would be eligible for OFLA. Remember, this doesn't affect eligibility under FEMLA. This is only Oregon law. It's just OFLA. Secondly, it eliminates the minimum hours worked requirements. You remember the 1250 in a year. That would go away. There would be no minimum requirement. So that would mean all employees who have worked at least 30 days, regardless of the number of hours that they work per week, would be covered by OFLA and in the right circumstances would be entitled to protected leave. But there's more. Excuse me. If an employee separates from an employer but is reemployed within 180 days of that termination date, that employee becomes immediately eligible for OFLA leave. This bill would eliminate disciplinary action for the failure to comply with leave notice requirements. Secondly, or lastly, and this is a huge change, the employee would determine the order or whether to use accrued leave and not the employer. Previously, we have advised you and told you to put in your policies with respect to OFLA that an employee is required to use any accrued paid leave they have when they go on OFLA. This bill would do away with that. Now, why am I so confident this is going to become law? Because both the House Speaker and the Senate President have signed this bill. This is now sitting on Governor Brown's desk. This is clearly the type of legislation that Governor Brown is likely to sign. And so I think we can be fairly confident that this bill will become law. Here is another one that I believe has a very good chance, almost a certainty, to become law. And what this bill does, Senate Bill 569, is it makes a driver's license requirement unlawful. So it would make it unlawful to require an employee or prospective employee to present or possess a valid driver's license unless driving is an essential function of the position for which they're applying or which they hold. It requires the employer to accept identification deemed acceptable on the federal forms, that is the I-9 form. Now, an employer can accept the driver's license if it is voluntarily offered by the employee. Now, again, the House Speaker and the Senate President have both signed off on this bill. It is sitting on Governor Brown's desk, and I think we can be very, very confident that Governor Brown is going to sign this into law. Now let's look at a couple of bills that I think are really long shots to become law, but are nonetheless interesting. The first of those is Senate Bill 483, which creates a retaliation presumption. It creates a rebuttable presumption of retaliation if adverse action occurs within 60 days of protected activity. Let me unpack this a little bit for you. What this applies to is the opposition to practices, complaints, initiation of proceedings, or reported assaults under the Oregon Safe Employment Act. The Oregon Safe Employment Act is a law that requires that employers provide a safe workplace. There are other provisions that relate specifically to nurses being assaulted and things of that nature, but this is the General Safe Workplace Act. And what this says is that if an employee opposes a practice, makes a complaint, initiates proceedings, or reports an assault, and then suffers adverse action within 60 days of that protected activity, there is a rebuttable presumption of retaliation created. In other words, what this would do is it flips the burden of proof from the employee to the employer. If that occurs within the first 60 days of following protected activity, it is presumed that there was retaliation. And the employer then has the burden of proving it was not retaliatory. The normal way in which a lawsuit proceeds is that the plaintiff, the employee, brings a lawsuit and then is required to prove that retaliation occurred. This flips that on the head. On the other hand, the bill specifically says if the adverse action occurs outside that 60 days, then we revert to the old system and the burden of proof remains with the employee. This bill may become law. It has some traction, but it has not yet passed either the House or Senate. It has not been signed by either the House Speaker or the Senate President. So, but this one's sort of in the in-between. This has a chance, but it's not clear. This is a long shot. Independent contractors, House Bill 2489. This is a bill which would apply to agencies, including BOLI, that have to make a determination regarding an individual's status as an employee or independent contractor. And what it seeks to do is set forth a standard that those agencies would apply in making that determination. And it sets forth a number of factors that the agency would have to take into consideration. The degree of control over the work. Is it the putative employer who's controlling the work, or is it the putative independent contractor who is controlling how the work is performed? The relative investment of the individual and the business. Did the individual have to buy their own tools? Did they have to procure licenses, make an investment in their business? Who controls the opportunity for profit? What that means is if the individual makes a mistake, who bears that loss? Does the individual have to make it right out of their own pocket, or does the putative employer cover that cost? The skill and initiative required in performing the work, to the extent there's more skill and more initiative required, that would seem to indicate that it's more of an independent contractor relationship. And then the permanence of the relationship. Is it a temporary relationship, or is it very long-standing? These are the factors that were being looked at. One thing that is, although this bill was introduced, one thing that is encouraging is that the Oregon legislature, in introducing this bill, didn't go so far as the tests we see coming out of California. We don't have the, you have to do something that's not done by the employer, et cetera. But this one, I don't think really stands a chance at all. Okay, our last bill that I think is interesting, but I don't think it's going to become law, and I think we all should breathe a sigh of relief that it's not going to become law. This is House Bill 2205, which is called the Private Attorney General Act. They have such a statute in California. And as Haley can attest, being a California practitioner as well as an Oregon practitioner, their Private Attorney General Act is the bane of employers in California. What this law would do would establish a procedure for private individuals to file actions in the name of the state against employers to recover civil penalties for violations of state law. That just opens an entire Pandora's box of potential lawsuits coming at employers from individuals who see what they think is a violation and decide they want to bring an action regarding whether they in fact themselves are the individual who has been impacted by the alleged violation of state law. Under the act, you would be able to recover attorney fees, and like I said, an analogous law exists in California. So that is your legislative roundup here. If you have any questions about it, please feel free to give me a buzz. I'd be happy to talk about this or any other bills which we didn't get a chance to talk about.